Welcome to the day breaking news. Here's the highlight of the day. Airbus loses bid to EU French blocking law in Qatar. London, July. A UK judge on Friday rejected an attempt by Airbus to invoke a de-Gulf era law, rejecting the way it responds to fucking course as a high-profile dispute with Qatar Airways became mired in a growing debate. Qatar Airways is suing France-based Airbus for $1.4 billion over damage to the paint test service and anti-lightning system on A350 jet, saying safety could be risked from a design defect. Airbus acknowledges quality flaws. Now, the two sides must provide each other with thousands of pages of documents as their dispute has towards the Rear London Aerospace trial in mid-2023, bearing an inclusive settlement. Airbus says it is prevented from directly handling over the documents sought by Qatar Airways by a 1968 law that stops French companies from handing over sensitive economic details to foreign courts without a special mechanism in place. The plane maker applied to a UK judge for permission to appoint a special commissioner responsible for transmitting the document to Qatar Airways, something it had already done to assist UK authorities during a bribery investigation. Failing to set up such a conduit would expose Airbus to criminal charges in France, the plane maker said. This is not something entirely novel, weird or wacky that we are proposing, its lawyer Rupert Allen told a division of the High Court in an online hearing on Friday. Judge David Workman, however, rejected the request, awarding costs to Qatar Airways. The 1968 law, widely referred to as the French blocking statute, was designed to protect French companies from oppressed foreign courts demand, especially from the United States, which with Paris is locked in an economic cold war. Thus, my judgment is a billion miles away from what this case is all about, Judge David Workman said. This is hardly the example of an unwilling, vulnerable French company that is now found itself having to cope with a highly intrusive and oppressive firm recovery, he said. He also criticized the plane maker for slowness over the request for a special disclosure mechanism. The jurisdictional role coincided with a simmering political debate in the UK over the rise of British and foreign courts following Britain's exit from the European Union. Tensions flared again last month when European Court of Human Rights, which is separate from European Union bloc, Britain moved to deport some asylum seekers to Rwanda. At least one of the candidates to replace Boris Johnson as UK Prime Minister has pledged to withdraw from the court. Deputy Prime Minister Dominic Raab, who is not standing on the congressional leadership race, has said Britain will be stay ECHR, but thus legitimate to push back. In France, a corruption case that led to a record €3.6 billion, €3.62 billion fine against Airbus from Britain, France and the United States in 2020 also fueled a debate over the extraterritorial reach of U.S. prosecutor against French company. Airbus said throughout the 4-year investigation that it was cooperating with all domestic and foreign agencies. Friday's ruling came after Qatar Airways urged the judge to invoke the authorities of English courts, which both sides had chosen to settle any disputes in their jetliner contract. Complying with the foreign law is no defense against non-compliance. The English court Qatar lawyer Phyllis Suher said Airbus pledged its commissioner would not personally review documents, but Suher doubted he would be a postback. Thank you for subscribing our channel. I see you in the next newsletter.